Okay, so I would like to welcome all of you to our online panel discussion today titled, Does the Government Have the Right to Control Content Moderation Decisions? And we're very privileged today to have two distinguished law professors who are going to be addressing some of these really important questions. In terms of logistics, the way this is going to work is I will briefly introduce our moderator, Leeza Arbatman. She will in turn then introduce the two panelists, and we'll be off and running with a set of questions and I'm sure a really interesting discussion. And roughly 40 minutes or so into the program, we will then turn to audience questions. So you're free using the Q&A to put the questions in at any time, although generally speaking, we probably will not get to them until later in the program. And I'll try to get to as many as we can, but typically with these things, we've run out of time. I'll also just mention by way of kind of context here, this event is being, first of all, I'm John Villasenor. I'm the director of the UCLA Institute for Technology, Law and Policy, which is at the UCLA Schools of Law and Engineering. And this event is part of a series of such events we do where we try to engage with scholars and the public more broadly on these really timely and important questions like the one that we're addressing today. So with that, let me just briefly introduce our moderator, who is Leeza Arbatman. She's currently a second-year student at UCLA Law, and she's actually conducting research at the UCLA Institute for Technology, Law and Policy on the scope of First Amendment protection for online expression. And she has also worked as an extern for the Honorable Susan Ilston at the U.S. District Court in the Northern District of California. And before coming to UCLA, she worked for a criminal justice organization, also interned at NPR member station KQED. So Leeza, I'm going to hand it over to you.
Great, thanks, John. It's a pleasure to be here, and I'm excited to talk about Section 230 and the government's role in content moderation with two experts in this area of law. So yeah, I'll go ahead and introduce our panelists and then launch into the discussion because there's certainly a lot of ground to cover. Eric Goldman, I'll start with you. Eric Goldman is a professor of law at Santa Clara University School of Law. He also co-directs the High Tech Law Institute and supervises the Privacy Law Certificate. His research and teaching focuses on internet, IP, and advertising law topics, and he blogs on these topics at the Technology and Marketing Law blog. The link to that blog should be in the event flyer, and it's blog.ericgoldman.org for all those curious. Before joining the Santa Clara Law faculty, Professor Goldman was an assistant professor at Marquette University Law School in Milwaukee, Wisconsin. And before that, he practiced law for 8 years in the Silicon Valley as general counsel of e-opinions and an internet and technology transaction attorney at Cooley Goddard LLP. So thank you, Eric, for being here with us. Our other panelist is Eugene Volokh, who teaches First Amendment law in a First Amendment amicus brief clinic at the UCLA School of Law, where he's also often taught copyright law, criminal law, tort law, and a seminar in firearms regulation policy. Before coming to UCLA, he clerked for Justice Sandra J. O'Connor on the US Supreme Court. And Professor Volokh is the author of over 90 law review articles, a member of the American Law Institute, and the founder and co-author of the Volokh Conspiracy, a leading legal blog. His law review articles have been cited by opinions in 8 Supreme Court cases and in several hundred court opinions. So thank you, Eugene, for being here with us as well. It's going to be a good discussion, I'm sure. So Eric, if I could start with you to sort of give us a lay of the land. At the heart of any discussion about content moderation is Section 230's role in immunizing internet platforms from liability. Briefly, can you explain to us what exactly Section 230 is?
Yeah, Section 230 is a law that Congress enacted in 1996, and it has 3 operative provisions, though I'm going to focus on one. The first provision, Section 230C1, shortly summarized, says websites aren't liable for third-party content. Section C2A provides extra protection for a site's filtering decision, and Section 230C2B provides protection for providing filtering instructions. And so going back to Section 230C2A, what it says in practice is that websites can avoid what I call the moderator's dilemma. The idea before Section 230 is that there were 2 main operative ways of proceeding. One is that services could moderate their content with taking full liability for any mistakes they made in the moderation process. Mistakes being allowing problematic content to continue. And of course, that has some significant downsides from a liability standpoint as well as a cost standpoint. And so a number of services before Section 230 took the other approach, which was to say, we're going to do as minimal moderation as possible in order to avoid the costs, avoid the liability. And that particular approach, of course, has its own downsides, which is that it allows the trolls to win. So Section 230 eliminated the moderator's dilemma, and it said you can take aggressive content moderation steps, or you could do no content moderation, or anywhere in between, and the liability outcome is the same. As long as it's third-party content, you aren't liable for it. So it treats the content moderation decisions like a dial that can be turned up or down as an internet service sees fit in order to cater to its audience. Now, one of the things that people sometimes don't fully understand about Section 230 is that it's what I call a speech enhancing statute. It sits on top of the First Amendment. The First Amendment sets a floor on the speech that's allowed in our society, but legislatures can, and not infrequently do, provide statutes that enhance the free speech in our communities. And so other examples are things like reporter shields, things like the laws that sometimes require a demand for retraction before you sue for defamation, or something like the Consumer Review Fairness Act, which bans certain types of efforts to control consumer reviews. So as a speech enhancing statute, what Section 230 does in practice is it takes the general free speech principles of the First Amendment and it gives them what I call a procedural fast lane. It allows for the quicker and easier resolution of lawsuits that would have potentially been blocked by the First Amendment anyway, but courts can now grant them on a motion to dismiss because the availability of the statute is clear. And it also lets courts do what we call constitutional avoidance. Courts would rather not opine on the Constitution if they could avoid it because of the fact that if a court says something's unconstitutional, legislature can't fix that. Whereas by letting courts decide whether or not a service is liable for third-party content by statute, the Constitution remains untouched by all those decisions.
Great, thank you for such a thorough answer. So to follow up, if you could just briefly explain what you think would happen. So if Section 230 were revoked by Congress or struck down as unconstitutional in court, what would be the impact on social media companies? Briefly, and we'll get more into this as the questions go on, but yeah, just.
Yeah, and so basically we go back to the pre-1996 world where we have the moderator's dilemma, where services are having to make that decision. Am I going to try to moderate content in a way that reduces my liability risk? Or is there some possibility that I could reduce my moderation with the hope that I wouldn't have the liability that comes from knowing or should have known that there was a problem on the site? Each of those approaches is a problem. If you're moderating content, it's costly. Being sued is costly. There's the risk of damages that could also be business ending. And so what happens in if a service tries to go the moderated route, they're going to engage in massive over renewals. If there's any risk of liability, they're going to remove that item. And they're probably going to control who gets access to the platform's publication tools anyway. Who gets the keys to publish on their service? They're going to take those keys away from people that they think might be risky. So you're going to see a shrinkage of the availability of people who have the power to talk in the first place. And those conversations are going to be much more controlled. If the site takes the perspective of saying we're going to do as little moderation as possible, they have a bunch of problems that are going to come from that as well. One, they can get takedown notices that then will give them the knowledge that they were trying to avoid, in which case they're going to have what we call the heckler's veto problem. They'll have to remove content upon notice. They might still be liable even if they never got a takedown notice. It depends on the statute or the claim and its standard for when they would have legally a legal consequence from what they've done. And so it's not even clear that there is an option for them to try to do as little content moderation as possible because they might still have that imputed knowledge for them. And if they are able to do that, that means that the spammers and the trolls are going to overrun the system, and they're going to dominate the conversation in a way that will drive away all the productive conversation, because the service isn't trying to control the people who are engaged in antisocial behavior. So the moderator dilemma comes back. Some sites will still be around with the possibility of a moderated content if they can afford it. Other sites will try to do as little as possible, be overrun by the spammers and the trolls, and those sites aren't going to last. And then the third option is that sites will just leave the industry and they'll simply say, there is no profitable niche for me anymore, and out I go. And so what happened in that circumstance is that UGC incumbents, the services that are providing user-generated content services today, are going to become entrenched. There's not going to be new entrants into that market, and most of the competitors will be driven out of the market altogether. So Google and Facebook will still potentially be around in that circumstance, but they won't have any competition. We're going to see a broad-based shift away from user-generated content towards professionally produced content that will come with less risk of being uncontrolled or not curated properly, and also might come with an indemnity. So what that means in practice is that there'll be less free content available because we got to pay the producers. There's going to be less diverse content available because the stuff that is currently available for free won't be monetizable. There's going to be less channels for us to speak, and there's certain categories that are just going to go away. So consumer reviews or online marketplaces or how-to videos on YouTube or Wikipedia or just the general social media as we know it today, those will all be gone. So what's going to be left is we'll have some paywalled walled garden type services that are providing professionally produced content that we have to pay to get access to, what I call the Quibification of the internet. And I know that's kind of a dated reference, right? Because Quibi is gone, but that should tell you something. And I think about a service like Twitter, what it's going to look like in that circumstance. And I think Twitter will still be around if they can make a profit, but they're only going to give the tools of publication and services to people like brands or celebrities, maybe also a Eugene Volokh. But a guy like me, I'm out the door.
I don't know about that, but thank you. That was very informative and thorough. Eugene, if I could turn to you. So for the rest of this discussion, we'll be focusing mostly on actions taken by social media companies to block content and users. Social media companies are private entities, and as such, they're not bound by the First Amendment and are free to block content and users as they see fit. Is that the end of the story, or are things potentially more complicated than that?
So I think that's an important part of the story. They are private entities, and generally speaking, private entities are entitled to allow whatever they want and disallow whatever they want on their property. And I generally agree with Eric about 230C1, that kind of immunity that platforms have, and that all websites that have comments and the like have, is a very important immunity. It does allow a lot of unpunished defamation and other such stuff, but on balance, it's probably better than abolishing it. But the interesting question has to do with 230C2. Which basically leaves platforms free, notwithstanding any country state laws that might be enacted, to say, look, we're not going to carry certain kinds of views or certain kinds of factual assertions or whatever else. So you might think of the world of entities that help distribute speech as being something of a spectrum. On one side is the newspaper and its close cousin, the magazine. They get to pick and choose what's included in their pages. That's true about articles, it's true about op-eds, about wire stories, about letters to the editor, about ads. And that's actually protected by the First Amendment. A case called Miami Herald versus Tornillo from 1974 says that a state's law that requires newspapers to publish replies to attacks on candidates is unconstitutional. I think that's quite right. And that's particularly obvious for magazines, many of which are self-consciously ideological. New Republic on the left, National Review on the right, there are plenty of others. You know, the reason we subscribe to them, if we do, is precisely because of what they leave out as well as what they include, right? If they had to include all stories, they would be useless because their editorial judgment is something that their customers are permanently seeking. Right next to the magazines and to newspapers is what we might think of as the bookstore, the newsstand. They don't actually produce the content. They don't really edit the content, but they also pick and choose. You could say this is a feminist bookstore, this is a capitalist or pro-free market bookstore, or this is a racist bookstore, or and the same with a newsstand. You could say, we're going to include certain messages, we're not going to include other messages, or we won't include this book because we think it's just unreliable or offensive or whatever else. That too, there's no Supreme Court cases on a First Amendment right of bookstores to pick and choose, but that's in part because there are really no laws limiting bookstores from picking and choosing. So I think that makes a lot of sense. On the other side of the spectrum, let's look at the post office. Now, the post office is run by the government, but it's not the only thing that is required to carry everything, including racist stuff, including fake news, including offensive stuff. Telephone companies. Well, you might say, well, they are monopolies. Well, what about cell phone companies? Like, for example, Verizon, T-Mobile, and the like. They are not monopolies. They're famously competitive with each other, but they're also, as I understand it, common carriers. They certainly could be made common carriers, but I believe the law actually provides that they're common carriers. Likewise, I think UPS and FedEx, which are rivals of the post office at a certain level, are common carriers. So let's say that I call up Verizon and say, Eric's been spreading all sorts of really bad ideas on his phone. In fact, if you call up his phone and see his outgoing voicemail is racist. Not that it is, but let's assume that's what it was. Or I'm going to forward to you a direct message that he sent to a bunch of people, and it shows that he is spreading falsehoods about COVID. Stop it. And Verizon would say, we can't stop it. We don't really want to stop it. We're not sure if you want us to be in a position to stop it, if you want cell phone companies to be the ones who are policing what is said by phone or by direct messaging or whatever else. And in any event, the law doesn't let us stop it because we're a common carrier. And again, the post office is quite similar. It used to be in the 19-teens, there was a case where the court upheld post office longstanding regime of basically saying, if something has a bad tendency to promote bad conduct, we're just not going to allow it in the mail. So it could be because it's sexually themed or because it conveys bad ideas politically. And the court upheld that. And Justice Holmes famously dissented, saying the government can abolish the post office whenever it sees fit, but so long as it carries it on, the right to use it is as much a part of our freedom of speech as the right to use our tongues. And then in the case called Hannigan v. Esquire in the 1940s, and then Lamont v. Postmaster General in 1965, the court endorsed Holmes's position. Again, that's a government entity, but it doesn't need to be. See, the phone companies, we treat them as common carriers, and we require them to carry all sorts of messages without discrimination. Now, they may be able to impose content-neutral rules. They could probably impose anti-spam rules. They can certainly create things that help facilitate users blocking. For example, they could set up their system so it's particularly easy for a user to block perceived spam calls. There's a service called Nomo Robo, which I've used on my phone for that. Or they could certainly set it up so that with one button, I can block any calls from a particular number. But they can't pick and choose themselves which ideas they don't want to spread or which facts they don't want to allow on their property. Is that a limit on their property rights? Absolutely. And certainly full-on libertarians, which many friends of mine are. I'm not a full-on libertarian. I'm libertarian-ish. Full-on libertarians say, there should be no such regulation at all. I can certainly see the downsides of such regulations. But it certainly makes sense to me that when something is relatively monopolistic, not necessarily in the antitrust law sense of an illegal monopoly, but even more so than the cell phone companies, where YouTube and Twitter, for example, Facebook and Twitter, are within their niches, such dominant players, that we might say we want to treat them as common carriers. Now, one question you might say, what about Miami Herald versus Tornillo? If a newspaper has a right to refuse to allow things in its pages, shouldn't Twitter have the right to block people from its computers? And the answer is the Supreme Court's cases do not support, I think, on balance, that view on Twitter's part. It's not open and shut by any means, but there's Turner Broadcasting v. FCC, which says cable operators, cable systems, may be required to carry channels that they don't want to carry. There is Pruneyard, which says large shopping malls may be required to allow people to come and speak on their property, even if they don't want that. There's Rumsfeld v. Fair, which says universities may be allowed to, may be required to allow military recruiters on their property, even though they don't want to have military recruiters there. So I think that's probably the First Amendment analysis as to any challenge to this kind of common, imagine the Social Media Common Carrier Act of 2021. It may be challenged on those grounds, just as net neutrality was challenged, but I am skeptical that it will be struck down. And then one question is it a good idea? Maybe it's a bad idea. Again, there are lots of good reasons to resist any new kind of regulation. I'm not sure. One question that I think we might ask ourselves is, what do we think about the 5th largest company in the United States, that's Facebook, having such extraordinary control that it can take a politician like President Trump, then President Trump, and just block him from posting. Likewise with Twitter, although it's a smaller company, although very big in its niche. Likewise with candidates, likewise with people spreading all sorts of views. Should we say, great, private entity, go right ahead, your private property, use it as you like to influence public debate? Or maybe we even say we praise you for it because we think on balance you'll influence it in a positive way. Or should we say, you know, we don't really want private entities to have that kind of power? Remember, at Citizens United, the dissenters actually argued private corporations shouldn't even have the right to speak about candidates. And I think they do. And I think Twitter has every right to post rebuttals if it wants to, or indicate this tweet has been questioned or whatever else. That's its free speech rights. But I think that, but certainly many people agree with the dissenters and even if one doesn't agree with the dissenters about the corporation's free speech rights, you might say corporations should have the right to speak, but shouldn't have the right to block others from speaking on their property, especially when their property is so central to public debate. So that's, I think, the strongest argument for why a common carrier type approach, with the platforms, of course, being free to speak themselves and to facilitate users' ability to block trolls. So, for example, nothing says that Twitter or Facebook would be barred from having a kind of user-based block this user from my page option. So, but I think once you have that, it seems to me that that's at least something that needs to be on the table as a matter to consider in deciding whether the kind of platforms are more in our ecosystem, a media ecosystem, are more like, or should be treated more like the phone companies than like the newspapers.
Would it be okay if I actually engage Eugene on this? Which
I
know every single person who's watching this is saying, Goldman, don't. You will not come out well from that engagement.
You have Yoda on your side.
Well, and I am going to use the force. Eugene, I've got maybe 2 questions and a comment. But let me start with the first question. You gave a litany of cases that you mentioned that might support the possibility of regulating social media as common carriers, but you didn't mention Halleck, and I'm wondering how Halleck plays into this.
I'm not sure that Halleck really does. Halleck says that this cable television system, and by the way, I should note, I was on the briefs on the losing side in Halleck. I shouldn't claim much credit for it, but I had helped out the lawyer in that case. But Halleck, as I read it, says essentially that a kind of cable provider, excuse me, a company that's being used in order to facilitate various kind of cable services, I think having to do with the public access television, is not a state actor for First Amendment purposes, if I recall correctly. And I'm not saying that Twitter and Facebook are state actors as such here. There's an interesting question about a different matter, which maybe we'll get to later on. To what extent can 230C2 be viewed, C1 be viewed, excuse me, C2 be viewed as preempted on certain theories? But setting that aside, they're not state actors. But nothing in Halleck says that government has to treat these entities that run public access television channels as fully private actors. In fact, it's quite clear that the government could say, we're going to set up this channel, this public access channel, and then we will impose a viewpoint neutrality rule on whoever it is who runs it. I think it would be entitled to do that, just as it could set up a viewpoint neutrality rule if it runs it itself. So I don't think Halleck is really that helpful, but I haven't really thought hard about how it plays out here. Is there some passage I should be looking at?
There's a lot of language in here that I think is directly applicable, and it does get to the point about state actors, but it really gets at I think the central premise of your argument that that we can tell operators of private property that they must or can't carry certain content. You have to have a reason to do that, and I think saying we would like them to be common carriers, I don't think gets you there. And I think that the Halleck case would be my citation for the difficulties, especially because it was a cable company. Exactly the kind of thing that in the past courts might have said we are going to treat closer to broadcasters than to publishers of print publishers. So to me, it seemed like the court was sending some really strong messages that, in fact, any attempts of the government to try to tell private entities what kind of speech they can or cannot disseminate is going to be looked at unfavorably.
Can I ask you just a bit, just since we're on Halleck, I pulled up Halleck, and again, I hadn't thought of it in this context, so my memory of it is rusty. But I see that the court in Halleck says that the New York regulations, which it seems to be approving of, in effect require the MNN, the Manhattan News Network, or whatever it's the acronym decrypts to operate almost like a common carrier. But under this court's cases, those restrictions do not render MNN a state actor. So I do think Halleck does make clear that it's not a state actor, and I totally agree that Twitter and Facebook are not state actors. But I don't see anything in Halleck that says that common carrier status, which it seemed to be referring to pretty approvingly there, would be unconstitutional.
So let me try my second question on with you, which is, do Facebook and Twitter have the right to terminate their users that cannot follow their rules? Or are you saying they simply can't have rules beyond a certain scope, which I'm not sure about? But if they conclude that a user has violated their rules, do they have the right to terminate them?
So right now, the answer is absolutely. That is to say, they have a legal right. There's no law that stops them. But I take your question to be, would they have a constitutional right to do this in the face of a statute that says you are a common carrier? I think the answer is it depends on the rules and whether the rules are authorized by the statute. So for example, my sense with regard to phone companies is that they can impose rules. One of them is you gotta pay. And if you don't pay, we'll terminate. Okay. They could probably impose other rules as well, content neutral rules, I suppose. Let's say if there is a rule, I haven't checked, but presumably there is one. If you don't let our repair people access your lines, and if you sick dogs on us, then we're going to cancel your service. I think that's fine. But I think if the rules are inconsistent with common carrier status, for example, people who have lobbied against our company or against legal rules that our company finds to be conducive to good business, we're just not going to do business with you. We're not going to allow you to have our phone lines. We'll terminate your phone service. Or if we think you're a racist, or if we think you're an Antifa, if we think you're a communist radical, we're going to terminate your phone service. And for violating the rules against using the phone service for communist purposes. I don't think those are legitimate rules for them to have. I think common carrier status says you can impose certain rules. Let's loosely call them content neutral rules, although that's an oversimplification. But you can't impose rules that essentially allow you to pick and choose which kind of speech you carry.
So my comment before I turn back to our gracious moderator is that if we view social media services as publishing third-party content, which is inconsistent with everything you've said, so I understand that I'm fighting your framing of it, then requiring them to carry government-produced content, such as like Trump's account, is exactly the kind of thing that I think we should be fighting against, and we should be looking for ways to avoid. Turning private publishers into mouthpieces of the government is what happens in totalitarian regimes. It's the kind of thing that I would like to think we wouldn't do here.
Well, so I appreciate that. That reminds me of the etymology of the word laconic, which I'm not, being a law professor. Laconic means terse in speech, comes from Lacedaemon, which was a term for Sparta. And apparently they were known being very economical with words. And one of the stories is supposedly that the Persian emperor sent a message saying that if I go inside the walls of Sparta, maybe not walls, inside the boundaries of Sparta, I will leave not one stone standing on the other. And they sent back a message saying, if. So yes, if we view these services as publishers, the way that 230C1 says we don't view them as publishers for purposes of tort law, but if we view them as publishers like a newspaper or a magazine, then in that case, I totally agree that they would have the First Amendment rights of publishers. But let's think about what if you view them as property owners. We know that private universities own property. They use that property to speak. Private universities are certainly First Amendment speakers. But when the government wants to go onto the property in order to engage in military recruiting, the court said in Rumsfeld v. Fair, there's no First Amendment compelled speech problem with the government requiring universities to let it in. Now, maybe the court was wrong on that, but it was unanimous on this point. And to me, a platform is in many ways like a private property owner on whose property people can speak, and whose property the owner itself speaks, as universities do. But especially when it opens itself up for a bunch of other people to speak, the government can either say, you must let in everybody, that's the Pruneyard decision, or you must let in a bunch of private speakers, that is the Turner Broadcasting decision, or even you must let in just us. That's the Rumsfeld decision. So I think under those cases, it seems pretty likely that the platforms wouldn't have a First Amendment objection to that. Now, I actually don't support the notion that the government should have special access. I think the government should have access, like President Trump should have access to, when he was president, to the same kind of account as others under this common carrier model. But even if it was a matter of government access, even that I think would be constitutional under Rumsfeld, rightly or wrong.
I'm sorry, I'm going to ask just a little more permission here. Eugene, how would you characterize a contract printer? This is not a company that's writing the content, but is simply got a printing press that's sitting there waiting for people to hire them. Right. Would you say that those could be turned into common carriers too?
Right. So it's funny that you should say that, because these issues actually come up quite a bit in the debate about people who have objections to providing services for same-sex weddings. I've actually filed briefs on both sides of that. I filed an amicus brief together with my friend Dale Carpenter, who's a leading scholar of law and sexual orientation, arguing that photographers, because they create speech, should have the right not to create photographs of weddings. We also filed a brief saying bakers, because they don't create speech, should not have a right under the First Amendment to refuse to create cakes for weddings, at least so long as they are cakes that don't have particular designs on them. That's an interesting separate question. So one question might be, imagine that Kinko's, the local Kinko's said, you know, we're not going to allow you to use our copy machines. Or we have some automated service where you just email the document to some server we have, and automatically it'll print it out on a nice cardstock for wedding invitations. But if it's for a same-sex wedding, we're just not going to do that. That's not a common carrier rules that might prevent that. That's anti-discrimination laws. But I'm inclined to say that I think that's probably more like Turner Broadcasting, where you're just required to allow things on your property, even if your property is a means for distributing speech, than it is an artisan, whether or a newspaper publisher or a photographer or a calligrapher, having to actually write this all out? So it's an interesting question, but I'm inclined to say that in light of Rumsfeld v. Fair, with regard to the university and its classrooms, which of course are places the university speaks all the time, but when it's not speaking, it has to leave them open. Likewise, with regard to Turner Broadcasting, if a cable company has to provide space on its cable, then I do think that a Kinko's would have to, or could be required to provide printing facilities. Now, I'm not wild about requiring Kinko's to provide printing facilities, in part because there are usually lots of copy shops around. But if it was the only Kinko's in town, and if somebody said, you know, if I want to have invitations for my same-sex wedding printed, it's got to be here, then I think there would be quite a strong argument that they should be treated as a kind of common carrier.
I'll just point out that in the 18th century, I think the idea that licensing printing presses about telling them what they could or couldn't print is exactly the kind of thing that I think was on the minds of the people who drafted the First Amendment, even if it wasn't the way we think of it today. So the idea that we could tell printing presses under a common carrier theory by bypassing the First Amendment that they must or can't print certain things, I don't know. That strikes me as a pretty aggressive argument.
You're absolutely right about can't print, because if a printer can't print anything, then that does mean that is a prior restraint on the ability to speak, because that material cannot be printed anymore. You know, I'm not an expert on the history of the First Amendment. I've written a few articles on it, but I can't say I have encyclopedic knowledge of that. I've never run into anything where they really talked about the compelled speech doctrine, especially in the context of printing businesses. I do think that they generally had a lot less regulation than we do now. They had some notion, I think, of kind of common carrier, like things like inns, I think, were for quite a while under common law treated as sort of like common carriers, places of public accommodation. But I'd be open to evidence that the framers would have thought it horrible to require the local printer to take all comers, because there's a fundamental right not to allow your printing press to be used for certain things. Maybe that would have led to a different result in Turner Broadcasting, but I don't know of any evidence on that, as opposed to restrictions on what a printer could print. That, I agree, would be a serious problem.
Sorry to interrupt, and I wish we could go on for a long time, but we have limited time here. And if I could turn to you, Eric, just briefly on a related question having to do with common carriers, but more thinking about internet infrastructure. Here's a question that's particularly relevant in light of Parler and everything that's been going on with that company. So suppose Congress were to enact legislation declaring internet infrastructure services such as Amazon Web Services to be common carriers, thereby requiring them to provide services to all without discrimination. Would that fly, or would that law be struck down on First Amendment or other grounds? And if you could be brief, just because we still have a few other questions, or a couple other questions to get through, and then the Q&A. But yeah, just a broad sort of.
Yeah,
answer.
I'm sorry for sucking up our time, but I just couldn't resist the opportunity to learn from Eugene's brilliance. I honestly think the last question that we just were discussing, this notion about treating contract printers as common carriers, really gets at the heart of everything underlying the question about other internet infrastructure providers. There's a wide range of different functions that they can provide as infrastructure providers, anywhere from, say, a domain name registrar, which simply provides an association between a web address and a IP address. And all they can do is turn that on and off, to all the way up to something like a web host, which is really actually often much more than an old style contract printer. They're providing the publication tools, but often with their own editorial contributions to that process one way or another. AWS is closer, I think, to the more fulsome web host. And so I view them as very analogous to it. And it really gets to something Eugene was talking about with this notion of what kind of competition is there in the marketplace. Something like AWS has many competitors in the marketplace, including the possibility of self-hosting. So a situation like that, we don't need to force any particular web host to be the web host. What we need is businesses to manage their vendor relationships in a way to make sure they have multiple vendors. Parler only sole sourced to Amazon. That was a huge mistake on their part, probably a reason why the Parler CEO lost his job. So the fact that there's competition in that marketplace, plus the fact that in the stack of telecom, all the way down from the physical layer to the full end user, web hosting is pretty close to that publication side of the equation. I honestly think that treating someone like them as required to carry all commerce would be a mistake.
You know, I think that's possible, and I totally agree with Eric that a lot depends on the shape of that particular business. If there are lots of competitors and there's always somebody to step in, then there's no need to regulate. I'll tell you the same thing with regard to weddings. If the bakery that we went to, my wife and I, would be considered an interfaith marriage. I'm Jewish, she's not. If they had said, you know, we don't want to make a cake for an interfaith marriage, I'd say, okay, no problem. Lots of bakeries out there. Whereas it would be very different to me if it were the only one in town. So I do think that matters. I think it's also significant, though, that my understanding is a lot of these businesses are pretty closely interconnected. And if Amazon says we want to essentially blacklist Parler, then any other hosting company might be afraid that they'll get blacklisted by Amazon or by Google or Apple, which also removed Parler from their stores. Because of their dealing with Parler. So the more you have these kinds of what sometimes is called, and I'm using this term loosely, secondary boycotts, where people risk being blacklisted by somebody because of whom they deal with, the more you might find that Parler has a very hard time finding anybody who could serve them. So I think a lot depends on the particular circumstances. My view is, of course, to those who know me, of course, my view is to prefer competition whenever possible, prefer free markets whenever possible to regulation. And I'm not even completely sure that we want to have cell phone companies be common carriers, but that is the decision that has been made. And I do think there is some force to it, especially when, returning to the earlier point, we're talking about speech and we're talking about marketplace of ideas and public debate. And you see these large businesses leveraging their economic power to very substantially influence the course of elections and debate. And again, there's a lot to be said for it. But there's also reason, even for those of us who are generally fine with private power, to say, you know, when the private power becomes so concentrated and so powerful and so likely to influence the political landscape, that's something that we might want to try to check.
Great, thank you. I think it's time to move into our Q&A. So I'll go ahead and pass along the questions that we're getting, and then either of you, whichever feel compelled to answer, and then if the other one wants to add, that will be great. So our first question here is, why does it have to be either or? Would the DOJ's proposal to beef up the good faith to require due process protection undermine social media as we know it?
Eric,
I do want to take this one. So just for those who aren't aware, there's been a number of proposals to reform Section 230. And in particular, there's been proposals from the DOJ and others that Section 230C1, the one that says that websites aren't liable, shouldn't apply unless there's, and let me see how the wording was, good faith of what? So good faith to require due process protection. I'm not quite sure that's what that means. The DOJ had a proposal that said you lose Section 230 if you don't operate in good faith, and it had some specifics about some transparency and other due process-like procedures that it then defined as good faith. So there's a lot going on in that question, and I really think that there's two fundamental questions. One, what would any change that's predicated on something like good faith do to the Section 230C1 fast lane procedurally that I mentioned? The thing that allows internet services to be able to win on motions to dismiss. Normally when you talk about good faith, you're going to have factual disputes, which guarantees that the case is going to go longer. to summary judgment, possibly to trial. If that's the case, then you've got questions about how much more does that cost and what will that do to the service's behavior when they're deciding, can I allow this content or not? The higher the cost, the less likely they're going to allow it. So, so I thought that the DOJ's proposal to introduce a concept of good faith was actually really going structurally at the core of what makes Section 230 actually work as effectively as it does. Now, some of the requirements for what the questioner said was due process like stuff. I think there's some really interesting questions whether or not the government can even require a company to provide notice of its terms, to explain why it made a particular decision that it made, and to provide appellate rights. Some of those were in the DOJ's proposal, and when we're talking about as a publisher of speech, if we're going to use that term, making them explain what their publication standards are, explaining why they made a particular publication decision or not, and giving an appellate right is, I think, really inconsistent with past practice, and I think might very well violate the First Amendment. So imagine if we were to require a bookstore to say, you must provide the rules about what books you chose to cover. You must give a book publisher who didn't get into the bookstore the right to get an explanation, and you must give them an appellate right that they get to go and say, you made a mistake on my books. I'm not quite sure we're allowed to do that. I think that would be really messing with the fundamental editorial decisions that sites have. So I oppose those types of proposals, both for the effects on Section 230's procedural fast lane, plus what I think might be some constitutional infirmities.
Well, so I think that it all depends on the if question, right? If they are like a publisher or like a bookstore, then I agree. They should be entitled to make any editorial decision they want, or any decision about whether to stock a book or not, without any explanation. On the other hand, if they're like a phone company, then it seems certainly not uncommon for the government to require that if somebody is going to somebody's service is going to be terminated, there be some sort of procedure, even within the private entity. If that's so, then I think there's no constitutional problem. This doesn't mean that it's a good idea. I do think a lot of people find it appealing just because it seems ethically appealing to say, look, we're not telling you what to do. You just have to go along with your own rules. But the problem is that either that becomes empty, like our rule is, well, if we think that this is bad, then we're going to ban you, okay? We think it's bad. We swear we think it's bad. So obviously that can't be enough if the due process rules end up meaning anything. So then it'll be, well, you need to define the rules precisely enough. Well, what about something that's trolling? Well, you have to define what's trolling and what is just good faith disagreement. And it ends up being, it's this lawyer, this kind of lawyer idea that more process is always good, right? Because it's fairer and it provides appellate review, and it could just end up being another procedural morass in which people, whether companies or users, will think. So I share Eric's concerns about those kinds of approaches, and I think in many respects it's better to have, although this Eric will disagree with me, just a rule that says you can't discriminate based on viewpoint and such, and then we might have some review to see if that's what you were doing, instead of having a rule that says you can set up whatever rules you want, but then we'll police them in some weird way. But I just don't think that it necessarily would be a constitutional problem unless you already conclude that those companies are like newspapers and bookstores more than they are like cable operators and like phone companies. And I'm not sure why you should think that they're more on that side, kind of the publisher or bookstore side, rather than on the platform phone company common carriers.
I guess somewhat in response to what both of you said, what do you think would be one positive policy or law step forward to improve the clarity of speech freedoms on the internet in the near term? What would either of you propose?
Eric?
Well, we are almost certainly going to then talk right past each other, because we're going to have this fundamental question. Are we talking about making the services are common carriers, and so they're exercising discretion that needs to be curbed? Or are we saying the real risk is government intrusion into how a private entity is handling its editorial policies, in which case that's the threat that we need to be fighting against? I view the situation as purely the latter, that the real risk to the internet is that the government now wants to tell internet services how they operate their business in a way that's going to force them to carry content they don't want or remove content that they would have preferred to keep. And those risks, I think, jeopardize all of our rights, and they're coming from the government. So to me, looking for ways to identify the government's intrusion into the editorial practices of internet services and curbing them is the way that we'll make sure that we have the maximum degree of free speech online.
Well, so let me just bring up something that I acknowledge is a somewhat distant analogy, but I thought might be helpful to some viewers, just if it works for them as an analogy. So I don't want to claim it's perfect, but this is an issue that has come up before with regard to private employment. So federal law bans employers above a certain size, I think 15 employees, from discriminating based on race, religion, sex, now sexual orientation, gender identity, age, disability, national origin, but not based on their political speech. So if an employer says we want to fire people because they're unpatriotic, or because we think they are racist, or because they support Trump, or because they support Obama, then in that case, that is perfectly consistent with federal law, because it's just a matter of the private property rights of the employer to say, you know, I'm just not going to send you a paycheck anymore. And of course, I don't expect you to show up to work. On the other hand, about half the states take a different view. California is one of them. California law, since 1937, I believe it's before any other of these state anti-discrimination laws in California was enacted, except maybe one having union membership. I'm not even sure about that. Since 1937, California has said private employers cannot fire employees for political activity. I'm oversimplifying here, but basically that. And political activity, the court has said, isn't just campaign-related activity. It is also any expression of views on any really contested issue. So if you think about it, that is definitely a burden on private employers. And I'm not at all sure it's a justifiable burden. You can certainly argue, you know, if you're fired because of your speech, even if you're a communist, or if you're a conservative or whatever else, you know, find another job. Nobody should have a right to work for an employer who doesn't want you working for them. So that's perfectly plausible. What's more, these laws do in some measure undermine the employer's free speech rights, even if the employer, even if they don't affect the speech that the employer actually engages in. You know, every time, let's say there's somebody who's a known communist who works at a time or in a place where people can't stand communism, works in a restaurant as a waiter, you know, that affects the message the restaurant is trying to send to the public. And maybe people will show up and feel uneasy because this person believes in violent revolution against the American way of life. So that it's a burden. It's a burden on the employer's speech. At the same time, I take it the rationale, and again, I'm not sure these laws are right, but I'm not sure they're wrong either. The rationale is you don't want private employers or government employers, but they're covered by the First Amendment already. You don't want private employers to leverage their economic power into political power. You don't want them to be in a position where by basically threatening to fire people based on their speech, or in fact firing people based on their speech, which is a threat to others, they can undermine kind of some political movement because people will be reluctant to participate in it. That's what the court, for example, held in 1979 as the gay rights movement, the gay court being California Supreme Court interpreting the statute, where in the gay law students case. In fact, the very first anti-discrimination laws, employment anti-discrimination laws in US history, were in the 1830s, and they banned discrimination based on voting. This was before the secret ballot, so when employers could discriminate based on voting. In a few states, they said you can't because, again, we don't want you to leverage your economic power into political power this way. So one question is that good idea, or is that an unacceptable burden on the private property rights of employers? And I think that's an interesting and difficult question, which, by the way, different states have resolved differently. California has one approach, other states have less protective approaches, others may have somewhat more protective approaches, others don't interfere with employer discretion at all. So I think we have a similar question here. To what extent should we be troubled that large business corporations are using their economic power to influence political discourse? Maybe in ways that we think are quite public-minded today, but of course there's no reason to think they'll be that way tomorrow. And thoroughgoing libertarians would say not at all. Free markets, free private property. And many others might say the same thing, but some others, whether on the left or on the right or in the middle, might say this is something that we didn't elect Mark Zuckerberg to do this, right? We're perfectly fine with him making a vast amount of money, providing very useful service. But we don't really want him picking which candidates and which office holders are allowed to speak in this tremendously important way to the public. So that's the question, how we should decide this. I'm not sure what the right answer is. You asked what I would suggest. I don't know. I really don't know. But I do think that we ought to be thinking about this as part of this big picture.
Great. So we just have a few minutes left. So if I could ask each of you to just give a 2-minute closing comment. Eric, maybe we'll start with you. Just anything you want to leave our listeners thinking about.
Yeah, I mean, you know, the idea that we could tell internet services how to operate their business should strike many of us as immediately something we're like, we better have a good reason for that. And the consequences of that for the internet, I think, could be potentially devastating if we do let the trolls and spammers win. And you know, I really think that Section 230 has been a boon because we've sidestepped so many of these constitutional questions by allowing them to be decided by statute. And I honestly think if we look at the amount of freedom that we have to reach audiences today that we never had in a pre-Section 230 world, we've been given an enormous gift and one that I'm willing to fight for.
Well, so I think Eric and I agree on many things. One is that indeed regulation of private businesses is something that should not be undertaken lightly and should be reserved for very unusual situations where there is a real need. Not everybody in the audience will likely agree with that, but on this, Eric and I agree. I also agree that Section 230 has been tremendously valuable, especially Section 230C1, which has provided the immunity that has made it possible for companies like Facebook and Twitter and the YouTube side of Google to exist. So I think it's an interesting question whether there ought to be some revisions to that, but I'm very skeptical about revisions to 230C1. This having been said, we're in a different time than we were 25 years ago. Back then, it was, well, you know, there's CompuServe and Prodigy and America Online, and you know, what kind of environment are they going to have? I don't think anybody envisioned there would be one such entity, in part because there were, especially with the internet, linking email accounts and web pages all over where you could access from your Prodigy account a page set up by someone at CompuServe and send email to them. People sort of thought there would be a lot of competition, and for a long time there was a lot of competition. But in large part because of the immunity provided by 230C1, coupled with the nature of network effects, where if you set up a large enough walled garden social network, that will give you an edge over smaller ones because more people will want to be on your site precisely because it's so large. Those two things put together, the 230C1 immunity and network effects, have yielded this environment where these entities are unparalleled wealth and power and monopoly status within their own particular niches. And as we see, whether or not it's some concerted plan, and I'm perfectly willing to assume it's not, competitors like Parler are being blacklisted in a certain way that makes it very hard for the competition to arise. So the question is the rule that we set up for a much more competitive environment with companies that were much less influential at the time still a sensible rule today, 25 years later, when we have a much less competitive environment where the companies are vastly more influential over politics? The answer is maybe yes. But I'm at least open to the possibility that it's time for a change, at least on the C2 side. And
the platform's power to block people, as opposed to C1 side, which is the immunity that platforms and others have from liability for the speech that they allow.
Great, thank you both so much. Unfortunately, we're out of time. We could keep talking for hours, I'm sure, but we'll just have to have another panel sometime soon. So yeah, thanks for spending an hour of the afternoon teaching all of us about this, and yeah, we'll look forward to the next one.
Thanks very much for having us.
Thank you. Thanks for everyone for coming.